I'm Professor Retselisitsoe Phooko from Northwest University, Mafikeng in South Africa. I'm also a visiting professor at the University of Lay Adventist in Kigali, Rwanda. This is a summary of my talk earlier today. The talk was titled Hope and Justice in the East African Court of Justice. What are the lessons for the SADC Tribunal or the Southern African Development Community? The talk looked at how the East African Court of Justice was established and how its judicial organ, which is the East African Court of Justice, assumed jurisdiction over human rights issues. I compared and contrasted it with the SADC Tribunal that was established in the year 2000, but subsequently got suspended or dissolved in 2011 after its power and authority was questioned by the government of Zimbabwe following the ruling that the land reform program had to make provision for those whose farmers were expropriated to be compensated. The East African Court of Justice was established in 1993 through the treaty establishing the East African Community. Its powers included on the interpretation and application of the treaty. The jurisdiction over human rights was explicit but was not operational. It could only be triggered by a subsequent adoption of a treaty. Following a case of Katabanzi versus Attorney General in Rwanda, the East African Court of Justice ruled that it had jurisdiction through implied powers to decide on human rights issues. Similarly, in the SADC region, the SADC Tribunal ruled in the Mike Campbell versus the government of Zimbabwe case that the SADC Tribunal, through implied powers, had the power and authority to adjudicate over human rights. The comparison and sort of differences or similarities between the two communities, that is the East African community and the Southern African Development Community, is that the East African community is still a judicial organ that gives, citizens of member states within the Eastern African community to have a form of redress at a regional level in case the domestic mechanisms are, for one way or the other, unable to provide redress. What is noticeable in the Southern African Development Community is that there is no judicial organ since the SADC Tribunal was suspended in 2011. This presents a serious challenge in that members of the SADC region will not have an opportunity to approach a regional body in the region of SADC to ask for justice in case their rights have been violated by member states. This represents also a situation wherein the SADC region has distinguished itself as the only region compared to the ECOWAS and the East African region that has no judicial body. This also presents a threat to investors, because they would like to see that when they interact or invest, at the very least, there is a form of redress where a domestic partner state wherein they've invested is unable to provide redress. From the Eastern African community, it could be said that there is a sort of a progressive development insofar as ensuring that there is access to regional justice. On the same side, it cannot be said on the SADC level that there is such, because of the absence of a judicial body. Another noticeable feature is that in the early operations of the East African Community of Justice, member states were to a large extent willing to implement the decisions of the East African Court of Justice, whereas that could not be said with the SADC tribunal insofar as the disputes between individuals and member states were concerned. The SADC tribunal experienced revolt insofar as the implementation and enforcement of its decisions, especially in the domestic courts of Zimbabwe. However, such decisions were eventually recognized in South Africa. The new envisaged tribunal is limited to the extent that it will not adjudicate dispute involving individuals. Rather, its jurisdiction is limited to interstate disputes only. I think that there are lessons that can be taken from the East African community, such as ensuring that the Council of Ministries in the East African Community Justice, which are involved for policy making, cannot work in a manner that will compromise the principles of democracy in the East African community. As the East African Court of Justice provide check and balances on how member states exercise their powers. This is something that can be learned, and it will be good for the progressive development of the region in SADC and ensuring that all SADC citizens have access to regional justice. It was good and an honor to present this lecture. Having written about the East African community about 10 years ago, I consider it a privilege that I was able to visit UNILAK and present in a member of the East African community about the research that I have been doing involving the two communities. I'll be here for 3 weeks. It's a different, culture, including its community. I've been particularly impressed, by the warm reception that I have received within the institutional community and the students. I particularly teach students on international criminal law and undergraduate students on international law. It has been a good experience, and also to explore the country, different cultures, and so on. I would be committing an offense if I were not to highlight the safety within the community. One can travel at any given time. The country is safe and beautiful. Thank you.